Hello there again. Welcome to the Employment Law Show here. John Scholes, your host, and with me, of course, Lior Samfiru, employment lawyer from Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. Right off the hop, I'm going to tell you how to get a hold of Lior and his amazing crew anytime you want to have that chat, discuss your employment rights, employment matters, and employment law for that matter. 1-855-821-5900, help@employmentlawyer.ca. That's the email you can go to all the time. There's also a website built just for you to use. It's anonymous. It's free. It's called pocketemploymentlawyer.ca. You'll learn a ton on the website. You can even go there before the phone call to Lior. And baked into that now is the Severance calculator, again, which is free and anonymous for you to use. Over 2 million of us have used the Severance calculator. So even if you don't need it, take it out for a spin, see how it works. Take you about 30 seconds. And you may be surprised at the number at the end of how much severance you are or would actually be owed if the time came around where you lost your job. So always go there first. It's your first step is pocketemploymentlawyer.ca. 5 workplace red flags. That is the main topic. A little later on the show, we'll get to that. Some phone calls. We'll go to terminationquestions.com. Some emails. Got a busy half hour coming up, so let's get into it, Lior. We always start off with the case of the day, the week that was. Pal, how are you?
Hey, John. Great to be here. As always, great to talk about employment law and workplace rights and hopefully solve a lot of those problems, those issues that come up all the time. I have a good idea always about what topics to talk about on the show because I spend most of my time not on the show. I spend most of my time in the office talking to real people, helping them navigate through those workplace issues and solve those issues. So I know that there's questions about severance and losing your job and changes to your job and maybe an employer implementing policies that you're not sure are legal or maybe temporary layoffs. Those issues come up. So we cover that on the show so that if it happens to you, you'll know what to do. You'll know what to say. You'll say, wait a second, I'm not freaking out here. I am not losing my cool, because I've heard about it. I understand it. That's the point of this show, and that's exactly what we try to do every week to arm you with that knowledge. So it starts here on the show, but it can continue by speaking to me privately and my team. You can call, you can email, we'll give you that contact information throughout the show. But we know what to do, so let's do it. Let me tell you about a situation that came across my desk. Now, John, you and I have spoken before on a topic called big mistakes that even large employers make, And the reason why that's an important topic is because of the fact that it's easy to believe that if you work for a large company, they must know what they're doing. They probably got it right. No, not so fast. And we've talked about that before. The mistakes that employers make are true both for large companies and small companies. And the matter that I've dealt with this week is a perfect example of that. I spoke with an individual who was let go after 22 years. A very large company. You would know the name. Not going to give you the name. Doesn't matter right now. But large company. Very sophisticated company. 22 years. Was offered 30 weeks of severance. 30 weeks of severance. That's, I don't know, somewhere around 7 months. Of course, that is not good. But he actually tended to believe that that's all he's owed. Luckily, his wife convinced him to give me a call, and he did. And why is that important? Because he actually was owed right around 18 to 20 months of severance. So 3 times what he was offered. Why am I telling you this? Because same thing may happen to you. We've heard about a lot of large companies that went through some mass layoffs, let a lot of people go. Don't ever believe that just because you work for a large company, they're doing it right, they're doing it legal. It's your job to determine if you're owed more. It's your job to make sure that your rights are being protected, not someone else's job. Now, this company, frankly, should have treated this 22-year employee a lot better. After all these years, all this dedication, they didn't. But the good news is it's not difficult to resolve. So large companies, small companies, if you lost your job, if you have other questions, don't assume the company's doing it right. Give me a call and find out.
Again, guys, 1-855-821-5900 is how you do that. You know, it's interesting. You mentioned a lot of large companies, and recently we've been hearing about tech companies. They had this skyrocketing success over the course of the pandemic for obvious reasons. And now it's like, oh, we got to start letting staff go. The vast majority of these companies are American-based. And they might be letting people go with severance based on the American model. And a lot of employees here on Canadian soil are going, well, I guess that's right. They would know it's the big bad company. They know what I get. A lot of people are getting shortchanged because of that, right? Why is that?
John, I've had, just in the last couple of weeks, dozens of people in exactly that situation. Large tech companies been let go, and they're calling me to know what their rights are. So let's break this down very importantly. If you work in Ontario, in BC, anywhere in Canada, it's the laws of that province that apply to you. It does not matter where the company is based out of. They may be based out of Delaware. Does not matter. It's the laws of your jurisdiction. That's very good, because in the U.S. they have very different employment laws than we have here, especially when it comes for severance. So in your situation, you don't really care where the company's headquarters. If you work and live in Canada, those are the laws that apply to you.
Employmentlawyer.ca. You can always go to that website too. By the way, to reach out to Lior, more information there. There's also a menu for media. There you'll find past radio shows, links to our television show. He does a lot of Facebook, a lot of FaceTiming there as well. Live chats, busy guy. But employmentlawyer.ca is where you want to go to find a radio station near you that carries our 1-hour radio show for almost 10, we're coming up on 10 years. That's pretty scary. It's getting a little white, more than it used to be. But we get a lot of great phone calls. You make a lot of effort to pick up a phone and call us on the radio show. And sometimes we cherry pick a few of them and play them back in this show for a learning experience, right? And we talk about them. Let's get to our first phone call from the radio show right now.
I was hired on 7 months ago approximately as an unlicensed assistant at a wealth management firm. They knew I wasn't unlicensed. They hired me anyway. They liked my background. 2 weeks after the probation, they called me in and told me it was my last day. When I asked them why, they said they decided to have someone who was actually licensed.
How old are you?
55.
What have they offered you?
1 week.
Wow.
1 week is what she was offered. So here's the thing. Obviously, it's not nice. It's not right to tell someone, yeah, no, we don't really care about your qualifications, come work for us, and then to be let go because you don't have the qualifications. But the question, of course, is whether that is legal. And the reality is, you've heard me say this before, an employer can let you go pretty much for any reason as long as they pay you severance. So yeah, not at all nice what this employer did, but the fact that she was let go because they changed their mind about that qualification, that in and of itself is not illegal. They can do that. The real question is, that 1 week severance, is that enough? I hope our regular viewers know that it's not even close, because even short service employees are entitled to substantial severance. So rather than me tell you how much this person is owed, let me show you how much this person is owed. We're going to do what we always do. We're going to use our severance calculator tool. We're going to grab our smartphone, go to pocketemploymentlawyer.ca, use that severance calculator, and let's see how much this person actually gets, and it's not 1 week's pay. So we know she's been there only for a few months. She's 55 years of age. She was offered 1 week severance. You see at the bottom of the screen there that she's owed up to 6 months of severance. Somewhere between 3 to 6 months. Yes, this is someone, John, that only worked for a few months, and she's owed 6 months severance. That's how it works for short service employees, and that's why it's so important. That's why we created this tool, our severance calculator. Check it out for yourself at pocketemploymentlawyer.ca.
And that brings about a good question. People watching this now will be saying, wow, that's her amount of severance for the amount of time she worked. It seems large, as opposed to someone who worked for a year, may get 5 or 6 months. Why is that? Why short service employees?
Well, just because you work for a company for a short period of time doesn't mean it's going to take you very little time to find another job. And that's what severance is intended to do, to compensate you while you're looking for another job. So if it's going to take you a while, you're going to get a lot of severance.
TerminationQuestions.com. I want to bring that website back into the fold here. Again, it's anonymous. It's free. It does exactly that. It gives you an opportunity to type in your questions to Lior and his team and get some answers about any concerns you have. First one for the show today. Let's get to it. Says, I'm off work right now because of a bad injury. I tried applying for long-term disability through my work benefits, but was denied. I appealed their decision, and I'm still waiting for a response. My boss says if my appeal is denied, it means I'm well enough to work and must return to my job or resign. What should I do? Wow.
Well, there's a number of things to unpack here, John, so I want to really do that. The first thing I'll say is this: the denial of the LTD, the long-term disability. If you get denied, which happens often, that appeal process, they dangle that in front of you. Just appeal here, it'll be fine. It's a waste of time. It's a waste of time. You're not going to change their mind with that appeal, because you're appealing to the people that have already decided you're not getting it. So what you have to do is you have to push back. We have a whole team at the office designed to exclusively deal with these issues, to make sure that they put you on benefits or they pay you compensation. So that appeal is a waste of time. You got to give us a call to deal with the insurance company. The second issue, of course, is the employer. It doesn't matter what the insurance company says. If you have a doctor that says you cannot work, then your company has to give you time off work. They can't say, well, the insurance company is not paying you, therefore you must come back to work. Nonsense. Those are separate things. All you have to do is provide your employer with a doctor's note saying you cannot work. They can't question that. They can't prefer someone else's view over that. So again, we may have a human rights violation here, a wrongful dismissal. So employers have to keep that in mind. And if any of this sounds familiar, your employer won't allow you to be off work, your disability insurer has cut you off, you have to give us a call.
That's an interesting point you made. And the other half of what we do here on this particular station is the disability law show, and that's why there's so much interplay between the two. And it can be a little bit of a dice game if you got to go somewhere else to do the disability portion, over here for the employment law portion. You guys have got the market cornered in that regard. It's all in the same office because sometimes you're doing that tennis match, right?
Those issues come up often.
Yep.
So you have a problem with the insurance company, now all of a sudden your employer is giving you a hard time, so we need to be able to deal with both, and that's what we do.
And we'll take a short break, guys. Get back into it. 5 employment law red flags, workplace red flags is coming up. In the meantime, reach out to Lior anytime, 1-855-821-5900 and help@employmentlawyer.ca. Lots more of the employment law shows coming up. Stick with us. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Thank you for hanging around. Employment Law Show. Still lots more to go here. Our main topic, as I mentioned off the top of the show, 5 workplace red flags. There's like 1,005, but we got to whittle down to 5 important ones and ones you should know. So we'll get into these right away, Leo. Our first one is this. Number 1, you've been put on a performance improvement plan by your employer.
So, John, a performance improvement plan usually is a step that an employer takes towards a termination for cause. If an employer thinks, well, we may have to terminate this employee for cause, they may start by putting you on a performance improvement plan so they can later say, well, listen, we tried. We tried to improve performance. It didn't work, so now we can fire for cause. And by the way, we don't even have to pay severance. So you don't want to help the employer do that. So when it comes to being put on a performance improvement plan, listen, if you agree with it, if it's 100% accurate, then that's fine. You don't need to deal with it. You don't have to worry about it. I guess just do your best and move on if it's accurate. But if it's not completely accurate, if it's not completely exhaustive, if there's things there that were missed, well, you have to do something about it. And what you do, of course, is you say so. You have to write to your employer, email works great, and say, well, you know, this performance improvement plan you put me on, here's what you really didn't include, or here's additional information that you have. Here's why I don't agree with it. You can still be professional, do that. You have to be respectful. I'm not suggesting that you accuse your employer of anything, not at all. But it is important that you put in your position that you understand, that your employer understands why it is that you don't agree with it. By doing that, you're going to preserve your job, you're going to preserve your ability to get severance if they do want to let you go, and they avoid a termination for cause. Remember, silence, not saying anything, it's exactly the same as if you just said, I agree.
And that goes for the employer if you make that complaint or say, here's how I disagree, but they don't respond to that?
It's perfectly fine. Okay. All I care about is that the employee respond. The employer doesn't need to agree. They don't even need to respond. As long as you've said something, so you're not being considered to have agreed and accepted it, that's all I care.
All right, employment red flag number 2 is this. Complaints of harassment and bullying are not taken seriously or investigated.
Well, this is an obvious red flag, of course, because an employer has that legal obligation. It's not just a moral, ethical obligation. It's a legal obligation to take these harassment complaints seriously, to investigate, and to do whatever they have to rectify the situation. And if they don't, that is illegal. So what happens if your employer won't deal with it? Well, you can ignore it and continue to be the victim of harassment. That's not an option. We all have a right to work in a harassment-free work environment, of course. So what do? Well, you push the issue. You follow up in writing. You make sure that they know and you have evidence in writing that you've told them to do something about it. You've told them about it and you've given them that opportunity. If that still doesn't work, if they still ignore it and they say, well, that's your issue, well, then we have to deal with it externally. That's where I come in. And trust me, if they hear from me, they're going to take a bit of a different approach. They're not going to tell me, oh, no, we don't want to deal with it. They're going to deal with it. And of course, we can also get you out of there as a constructive dismissal. So it is a red flag and one you shouldn't accept. Too many people try to deal with harassment, and if the employer doesn't deal with it, they kind of give up and maybe they resign because they don't want to work there anymore. Don't do that. You have a right to have those harassment complaints dealt with seriously. And if you find that they're not being dealt with seriously, give me a chance.
You always know my follow-up question to this one is, what if the boss or the person you're supposed to report to is the one harassing you, right? You feel stuck.
Yeah, well, who are you going to complain to if it's the owner of the company that's harassing you? No one's above the owner of the company. Well, at that point, there's no point dealing with it internally. We have to deal with it externally. That's when I get involved even earlier in the process. But either way, you have rights, you have options, and you shouldn't just accept harassment ever.
Employment law red flags. We're going through 5, but there's a lot more, but we'll get through 5 in the show today. Number 3 is this, guys. You are penalized or refused accommodation due to an illness or disability. How about that?
Well, I mean, talk about red flags, talk about illegal activity. That can happen. You have a right, if you need to be accommodated, to get that accommodation. And so whether it's a situation where you need modified duties or modified hours, maybe the ability to work from home, maybe time off for doctor's appointment, if you need that for medical reasons, well, guess what? Your employer has to find a way to make it happen. They have to accommodate. It's not enough to say, well, it's kind of a difficult thing to do. Even if it is difficult, they still have to do it, okay? And there's no option here. And if the employer goes the wrong way completely, and now not only are they not accommodating, they're penalizing you, they're punishing you, they're suspending you, they're letting you go because you're sick or you need accommodation. Man, oh man, that law is going to come down pretty hard on that employer. Human rights violations, employment standards violations, wrongful dismissal, you name it, it is illegal. So always remember, have that doctor's note if you need accommodation. Okay? Take that doctor's note to your employer. Tell them what it is that you need. If they don't cooperate, or certainly if they try to punish you in that situation, you get on the phone, you call me right away.
All right, employment law red flag. Number 4 is this. Your pay, schedule, responsibilities have been changed significantly, right?
Red flag. We're talking constructive dismissal. I hope our regular viewers know this term by now. They should be kind of very familiar with it. Your employer doesn't have a right to make significant changes to your terms of employment. They don't have a right to reduce your pay, to demote you, to change your work location, to change your schedule. They can't do that. But of course, no one's stopping you from accepting that. So we're talking about red flags here. Accepting that, telling your employer, you know what, I'll continue working, I'll be a good team player and continue working. By doing that, you've just made your situation worse, because now what's just happened is you've given the company the right to do it again. So they change your shift, maybe they added 1 weekend a month, and you accepted it because you wanted to be the team player. Okay, well, by doing that, you've now given them a right to add a second and a third weekend. Why? Because you let it happen that first time. It's a red flag. So whenever the company makes a significant change to the term of employment, you want to really think, am I okay accepting this, and am I okay with this happening again and again? If you are, that's fine. You continue working, no problem. But if you're not okay with that, if not, it's not something you can live with, it's the time to consider then constructive dismissal. That may allow you to leave and get your severance because the company is not living up to its side of the bargain. So you have that right, you have that option, you don't want to ignore it.
Being a team player is generally a good thing. You know, employers want to get the team player on their team. So is there some sort of, I'll do it, but with this caveat that I'm just taking it out for a little bit of a try. I don't know if this is going to work for me. Can you do that? In writing, of course?
You can. You hit the nail on the head. In writing. Anything in writing. So if your employer, let's say, is going to give you, again, I'll use my own example, a week and a month now you have to work. Say, well, employer, I'm going to work a couple of weekends and see how that works for me, and then we'll discuss it. So you put that in writing, send in an email or a text message, and then after a few weekends, if you like it, you're okay with it, no problem. If you don't, you still have the opportunity to say, well, wait a second. I told you I'm only going to try this for a little while. I did. It's not working for me. It's not something I'm willing to accept. So either we go back to the way things were, or it's a constructive dismissal.
Employment law red flags. Number 5 is coming up right here. This one is huge, and you're being pressured to sign a new employment agreement despite years of being on the job with this employer.
red flag. There should be lights, red lights flashing all around you. If you're walking into work one day, it's a nice weekday, and you're thinking, I'm going to get my job done, maybe I can even leave early today, and instead you're getting an employment agreement to sign. It's a bad idea. It's a bad thing. There's no good reason, and I say good here, as to why your employer decides all of a sudden that they want you to sign a new employment agreement. The only reason an employer would want that is because it provides for better terms for the employer. There's not something in it for you. Even if your employer says, you know what, we're going to be nice. We're going to give you a little raise, actually. Just sign this employment agreement. How much better can it be? Well, that employment agreement likely takes that raise, fine, but you lose severance on the back end. For example, it may say that if they're letting you go, you're getting a fraction of the severance. It limits your severance. Or it may give the company the power to change your job. Or it may give the company the power to lay you off temporarily. Other things. So it's always a red flag. Don't just accept and sign that employment agreement. If you want to know what it says, what it does, and how it affects you, send me a copy. Let me see it. I'll read it and I'll tell you, is it a problem? Is it not? Should you sign? Should you not? But if you sign that employment agreement, you probably will find out later, maybe when it's too late, that you've signed off on giving up your rights, and you never want to do that.
If you've signed off on it, but they didn't give you a little perk for doing so, where do you stand now?
So that's kind of the next level of the analysis. Strictly speaking, for an employment agreement, really any agreement to be valid, you have to get something in return for signing. So you signed the agreement. If you didn't get anything, it's probably not enforceable. But if you got something, a pay raise, extra vacation, a signing bonus, if that's what you got, then it is enforceable. Despite that, never sign an employment agreement, or really any agreement, thinking that it would be unenforceable anyway. It's always a bad idea. So my best advice is, if you're not prepared to live with it, don't sign it.
Again, employmentlawyer.ca is the website you want to go to for all matters, and to reach out to Lior and his team, and find a radio station that covers our show across the country pretty much. And we'll get to phone call number 2 from our radio show. We'll talk about it right now.
Company for 2 years now. Vice president came to me and offered me a promotion, I guess, provided 3 different options, or he would sign my papers to release me. Initially, I showed interest in the key accounts position, decided that I want option number 3 for him to release me, and now he's asking me for a letter of resignation saying that he doesn't owe me anything.
So, well, there you go. There's the reaction right here.
First, we want to promote you, and if you don't want it, get out.
Yeah. No, resign.
That's right.
My God. So there's so many things in this very simple, short question. There's so many things to break down here. So let me try to do that. First of all, you certainly don't have the obligation to accept a promotion. Some people may be happy, but you may say, you know what, the extra work is not worth it for me. I'm happy to stay where I am at. I don't want a different job, and that's fine. You can't be penalized for that. That's not a resignation. That's not ground for termination for cause. So right off the bat, we know that. The second thing is this, John. If your employer wants you gone because maybe they're upset you didn't accept a promotion, okay, well, they have to pay you severance. They have to let you go on a without cause basis and pay you your full severance. You don't resign because you don't accept a resignation. You only resign if you've decided yourself that you don't want to work there. There's no such thing as, well, I accept or I expect your resignation. Well, you can continue expecting. You're not getting it because I want to continue working. So right off the bat, this is illegal. And anytime you hear your employer telling you that they expect your resignation, the answer should be thanks, but no thanks. I'm going to continue working here until you, Mr. or Mrs. Employer, decide that I am not. And then you have to pay me my full severance. I'm not going to give you a way to avoid paying me my severance.
That was a great call. I want to get to one more, though, before the end of the show. We're going to do that on the other side of this quick break. In the meantime, always have that number ready to call Lior and the team, 1-855-821-5900, and help@employmentlawyer.ca. We'll continue. More of the Employment Law Show's coming up. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. Good to have you for the entire half hour if that's the case. If not, you can always tune in online and find past shows. You can also find a radio show online at a station near you that carries that. Hour-long programs all week long, pretty much across the country. We get a ton of phone calls on the show, and it's great because some of them are absolute doozies. That's why we play them back here, because it's always a learning opportunity. I mentioned another phone call I want to get to, and we'll do it right now. Hang on.
I've been with the same company for 8 years. I worked my way up to the customer service manager. I recently went on sick leave. When I came back, promoted somebody from underneath me with no management experience to be my boss. Responsibilities that I had before are no longer mine.
Would you consider this a demotion?
Absolutely.
Wow.
Yeah, it's not nice.
It's not nice, but I'm not here to talk about nice. I'm here talking about legalities, and it's not legal. You cannot be demoted. Nothing can happen to you really because you were sick, because you took a medical leave or a disability leave. That can't happen. You can't be punished because of that. That's a protected right that you have to be sick. And then if you are, the law protects you. We have human rights legislation that say you cannot be punished. So if in fact she was demoted, she said, absolutely, this is a demotion because she was sick. In other words, she wouldn't have been demoted otherwise. We have a human rights violation here. Illegal, can't do that. The second thing is, even if we decide to forget about this human rights violation, which we're not, but even if we are, it's still a constructive dismissal. An employer doesn't have a right to just demote you, regardless of pay, by the way, because it's going to be embarrassing, right? If you're demoted, people are going to think, what have you done wrong? So usually if we're talking about a real demotion, a company doesn't have a right to do that. And if they do, that results, as we said earlier, in a constructive dismissal that allows you to leave and get severance. So, of course, the final question here becomes, okay, constructive dismissal, we get that. How much severance is she owed? So once again, we're going to do what we did before. We're going to use our severance calculator tool. We're going to go to pocketemploymentlawyer.ca. First thing you see there is our severance calculator. Let's use it right now. Let's see how much severance this person actually gets. So she's in a managerial role, or at least was before her demotion. 8 years of service. Constructive dismissal, so the company has not offered her any severance, but you see there she's owed anywhere from 12 to 14 months of severance. That's 12 to 14 months of her total compensation, salary, bonus, benefits, car allowance, etc., etc. That's why it's important to understand that if you have a constructive dismissal, if you have been constructively dismissed, you have significant entitlements, and in this case, also human rights issues.
I want to get to a quick final question here from one of Lior's live stream. That's on Facebook and YouTube and LinkedIn as well. You go to ST Lawyers to catch those live streams. It says, I was fired for cause for breaking the drug and alcohol policy. I've been honest with my boss about my struggles with substance abuse and mental health for the past few years. He refused to help after I asked for assistance. Do I have any options?
So the law recognizes that alcohol dependency and even drug dependency is a disability. So if you're struggling with alcoholism, you have a disability. And that means that you can't be fired because of the symptoms of that disability. And unfortunately, one of the symptoms of that disability is you may drink when you're not supposed to. And it's not because you're a bad person, it's not because you're irresponsible, it's because you have that disability. So no, you cannot just be fired because of it. If your employer is aware that you have that disability, they're aware that you're struggling with alcohol, they can't punish you. Now, I'm not saying that they should be allowing you to work while you're intoxicated. Absolutely not. But you can go off on a leave, whether it's paid or unpaid, depending on whether there's a disability plan. And when you're cleared to come back to work, they have to accommodate you. Very, very important. So in this situation, company says, no, you drank, we don't care, anything else. You're gone, you're out of here, you broke the policy. That is illegal. That's a human rights violation, not acceptable. If that happens to you, the law does protect you, and your employer should know better.
It's interesting, too, because in drug and alcohol abuse, even when you're getting rehab for it, you're in a STEP program, it's ebb and flow. You may fall off, come back, fall out. That's expected. It doesn't mean you're being delinquent. That
is one of the most common symptoms of that disability is you may go up, you may go down. It's not going to be a linear line. And the law understands that may happen. That's why you have to be accommodated.
Another phenomenal show. Appreciate you tuning in. And you can always participate in the show in the following weeks. You can send your emails to help@employmentlawyer.ca. Again, employmentlawyer.ca to find a radio show near you. Call in, talk to us. And then finally, the phone number, 1-855-821-5900. We'll catch you next time.